Hello, my name is Jacqueline Wolfe Tice. I work for the University of Oklahoma College of Law in the Indigenous Peoples Law program. I live on the Aboriginal land of the Lenni Lenape Nation. I am not an enrolled citizen of any tribe, but through family ties, I am affiliated with Cherokee Communities and the Mandan Hidatsa Arikara Nation at Fort Berthold. This presentation will answer three questions. They are, what does the federal government and government policies have to do with tribal interests and natural resources? What amplifies the conflicts in that relationship? And how can scholars and students work with tribal stakeholders to support sovereignty while protecting natural resources? I've decided on 6 points of departure from my abstract for this talk to help answer the questions posed in the last slide. This is important baseline knowledge, and I'd like to start number one with the fact that natural resource law and policy is inherently ethical and political for tribes. When you consider the cultural values, there are extremely disparate objectives between the US and indigenous peoples' relationship to natural resources. Western civilizations historically have been driven by colonial conquests on Indian lands, expansion, development, and essentially excessive mining of natural resources. These values contradict the inherent indigenous land ethics, which focus on Earth as a living being and our relationship to her as a duty and a responsibility. For example, the Dene Natural Law, which is contained within the Navajo Nation Code, establishes that all creations, including animals, those who live in the water, those who fly, and the plant life, have their own laws and have rights and freedoms to exist. That conceptual framework and approach to land and water is very different and important to keep in mind. Three specific sovereigns are mentioned in the US Constitution, Article 1, Section 8, Clause 3. The Commerce Clause says that Congress shall have the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. This establishes that there are three sovereigns within the boundaries of the United States, and that fact has been upheld in countless cases by the Supreme Court. Number three, Indian natural resources are protected or limited by treaties, statutes, executive orders, and judicial review. These instruments have established and affirmed the special trust relationship that exists between tribes and the US. The US has federal trust responsibility, which is a legal obligation under which the United States has charged itself with moral obligations of the highest responsibility and trust. This responsibility includes, of course, fiduciary obligations, but is also an obligation to act in the best interest of tribal nations. Number four, sovereignty equals justice. This is a crucial construct when dealing with tribal nations. Sovereignty is an exercise of economic, political, cultural, and territorial means to self-determination. Sovereignty of tribes predates contact with Euro-Americans. The government-to-government relationship between US and tribes exists as a wholly distinct form from any other group of Americans. I suggest in this presentation and through my research that intersections with tribes must be viewed first through the lens of tribal sovereignty in order to secure just laws and policies. There are existing doctrines that support this. In theory, the canons of construction are legal doctrines that basically construe treaties and statutes as the Indians would have understood them at the time. This shows up in a lot of cases. The reserved rights doctrine, of course, is one of the important doctrines for natural resource law. It was first brought to bear in United States v. Winans in 1905. And this is a case where the treaty rights were preserved, the treaty rights of tribes. Winans admits that there are pre-existing and preserved rights reserved by tribes and acknowledged by treaties. Generally, reserved rights are rights reserved by treaties, agreements, and other means wherein the tribe forfeits or cedes lands in exchange for reservations. So a reserved right is not a right specifically granted to the Indians, but it's a grant of rights from the Indians. In other words, a right not specifically forfeited by a tribe is reserved by them. And it's important to understand this. It's a critically important construct of Indian natural resource law, and I'll discuss implied reserved rights later. The Department of the Interior houses many offices impacting tribes. The Bureau of Indian Affairs is the oldest agency, and this bureau manages 55 million surface acres and 57 million acres of subsurface minerals, which are held in trust by the United States for tribes and tribal citizens. The BIA facilitates the government-to-government relationship between U.S. and tribes, which is why it's so important that an indigenous person leads the agency now to foster more self-determination for the 574 federally recognized tribes. The natural resource situation and intersection with the DOI is really about not only the trust responsibility, but also the money from oil and gas and timber and mining, because it's estimated that Indian reservations contain 30% of the coal reserves west of the Mississippi, 50% of potential uranium reserves, and 20% of known oil and gas reserves. The DOI oversees all of that in Indian country. There are laws and regulations that govern the development of fossil fuels as well as sustainable forms of development. And I have a slide on that later. If you don't think Deb Haaland's appointment is significant as the Secretary of the Department of Interior, here are just two examples. Recently, ANWR is an area of great concern, and the Arctic National Wildlife Refuge is not only important as we are talking about climate change, but also tribal communities, the Inupiaq and the Gwich'in peoples, have had subsistence rights there for many millennia. So that's part of part of the changes that are happening. The Department of the Interior suspended the oil and gas leases just recently. And at Fort Berthold, where my relatives live, again, the Deb Haaland has essentially reversed a ruling by the previous administration that had overturned 80 years of a precedent. The Mandan Hidatsa Arikara Nation is an energy tribe. They do develop, and they are entitled to the rights of the riverbed of the Missouri River. So they now are back to having that right, whereas the last administration had tried to suspend their right to that. Indian country is actually a political and a legal term. It is essentially it has a definition under Title 18 of the U.S. Code. Title 18 is the criminal code. And it's that way because jurisdiction is king when it comes to federal Indian law and policy. So we want to have a definition that's clear. You can look over this. I have a limited time on this in this presentation, so I'll be going through these very fast, and we'll be talking about them in the real-time Zoom sessions that we have during the conference. So having a definition for Indian country is highly helpful for tribes. The McGirt decision in 2020 actually was a really important decision because McGirt challenged Oklahoma. McGirt was a tribal citizen who challenged Oklahoma that the crime he committed was done in Indian country, so the state had no state jurisdiction by way of the 1833 treaty with the Muskogee Creek Nation. And for the court, Neil Gorsuch wrote the opinion that affirmed the reservation itself was never disestablished, and therefore a good swath of the state jurisdiction is now the purview of Indian country, which is under federal and tribal jurisdiction. This issue of authority is all about jurisdiction. Within Indian country itself, and on we have reservation land, but we also have four primary categories of land: trust land, fee or fee simple land, restricted fee land, and allotted lands. And I'll talk a little bit about allotted lands. Allotted lands were the result of the Dawes Act, and it fractionated tribal communal land into individual plots. And Theodore Roosevelt called it the mighty pulverizing engine to break up the tribal mass. So US policy was not kind to Indians during the assimilation period. And land status contributes to a morass of jurisdictional regulatory situations and cases that come down in Indian country. So to illustrate some of the ways in which the U.S. and federal Indian law intersect, it's important to understand that there are foundational and essential statutes and cases that have provided the basis for Indian law and policy. And the courts use these statutes and they use these cases to decide and enact justice, essentially, and interpret the law. Chief Justice John Marshall was a lauded jurist in the 19th century, and he legislated from the bench through this Marshall trilogy. And I'm not going to go over all of these, but essentially the discovery doctrine was made essentially to law in the Johnson v. McIntosh case, which was the first essential Indian law case. Tribes were given occupancy status during that case instead of title to the land. Later cases, Cherokee Nation v. Georgia and Worcester, tribes were called domestic dependent nations, and the U.S. was a guardian to the tribe's ward, and the trust relationship was established. And then, all law and policy has really kind of come out of these three cases for the last 150 to 200 years. So these particular statutes here, I'm not going to go over them. I'm going to discuss them with you at the live Zoom that we have, but I invite you to take some time and look at these. Case law considerations: the role of courts is to interpret law, and natural resources is about protecting and determining jurisdiction. That's a first order directive. The second is what uses and consumption is the highest and best use of natural resources within the existing law. I'm going to just go over briefly two cases. One's for timber and one is for water. The Teton case in 1955 asked the question, did the sale of timber constitute an illegal taking under the Fifth Amendment? Because the U.S. came in and took timber from what was thought to be by the Tlingit tribe Aboriginal titled land. So the court came back and said the U.S. is not compelled by any congressional act or constitution to pay for the timber. So what happened is that Aboriginal title was only an occupancy right, as we saw in Johnson v. McIntosh. Very quickly, I'm going through these. The next case that we have is Winters v. U.S. This is a water case, and this held reserved rights, but implied reserved rights. So, and I want you to just read through this slowly, but basically in this, the canons of construction helped and said that the ambiguities are resolved in favor of Indians, and that when a reservation is established, the tribe has the right for reasonable use of the water. They protected sovereignty, they upheld treaties in this, and by extension helped to maintain the ecosystems. With about 30 seconds left, I want to say that understanding and considering sovereignty as a context for everything when working with tribal entities is essential. I encourage you to read and subscribe to Indian media, Indian-produced media, and to explore books and articles. I have a lot of things to talk about in the upcoming Zoom meeting, and thank you so much for listening to my presentation today.